question. NPR's legal affairs correspondent is Nina Totenberg, and she is now joining us live. Nina, I appreciate your time. I want to get a sense from you as we hear from the administration. They're in a challenging position right now to try to find out how to better accommodate individuals, and obviously casting this as a very narrow decision. But clearly it does affect a large number of individuals. So I want to get a sense from you. What are the next avenues on both sides for the opponents of Obamacare and for those who say that this decision was simply wrong?
Well, you know, whether this was a narrow decision depends on your point of view. Those who won say it's narrow. If you talk to, professors, which I've already done, who sided with Hobby Lobby on this and against the administration, they say that the court has signaled that other kinds of challenges will lose. Those who want to claim that they don't have to pay for immunization or blood transfusion or other objections to civil rights objections, for example, based on religious belief. But those things are actually not hammered out yet. And what the court has said so far is that closely held corporations, that is, they don't have public shares, closely held corporations, maybe even just family closely held corporations, but for sure closely held corporations, do not have to abide by the ACA's requirements if it violates their religious beliefs. Now, there are a lot of very, very big closely held corporations in this country, from Comcast to Bloomberg to Cargill to, there are dozens of them. And it's true that many of them will want to just comply with the ACA and have insurance programs that provide all FDA-approved contraceptives. But if they don't, then the administration is going to have to come up with a solution that is perhaps like the solution they offered to nonprofit religious institutions.
So give us a sense of the consequences. What are the ramifications? Where is the next page in this chapter?
Well, I'm not sure. The court did seem to try to make this as narrow as possible so it wouldn't be opening the floodgates, but it's not 100% clear whether it has done that or not. I think what is pretty clear is that there's at least one justice, in the majority, Justice Kennedy, who wrote a separate opinion. He signed on in full to this opinion, but he wrote a separate opinion that said, essentially, don't worry, as long as I'm here, the floodgates won't open, and it won't be hundreds and hundreds or thousands and thousands of companies saying, why me? Why should I have to do this? Or why should I have to do that? But he is the fifth vote. It's not at all clear where the majority will lie, for example, in challenges to certain sex discrimination practices that may occur, that somebody will say that's against my religious belief, or cases involving gays and lesbians, or cases involving people of different foreign origins. It's just not clear.